I knew something was wrong the moment I saw the construction crew breaking ground on what should have been the empty lot next to my house. But when I walked over with my morning coffee to investigate, I realized they were not just next to my property line, they were a good 15 feet over it. My name is Quentin Jacobson, and I had lived in the Meadowbrook Heights subdivision in Chandler, Arizona for exactly 3 years. I bought my corner lot specifically because it was larger than most properties in the neighborhood, giving me extra space and privacy. The land survey I received during purchase clearly showed my property extended well beyond where my fence line ended, wrapping around the side yard in an L shape that included a significant portion of undeveloped land. The construction workers were already pouring concrete footings when I approached the site foreman, a burly man in a hard hat who was reviewing blueprints on a makeshift table. "Excuse me," I called out over the noise of machinery. "Can you tell me what's being built here?" He looked up, squinting against the bright Arizona sun. "New parking structure for the HOA. Should be done in about 4 months. Going to have 40 spaces, 2 levels." My stomach dropped. "And who authorized construction on this specific location?" "The HOA board, I guess." "We just go where the plans tell us." He tapped the blueprints with a thick finger. I set my coffee cup down on the corner of his table, trying to keep my voice level. "I think there might be a problem. I own this land. My property line extends to about where your concrete mixer is sitting right now." The foreman's expression shifted from casual disinterest to concern. "You sure about that? The HOA gave us permits and everything, said this was common area land." "I'm absolutely sure. I have a survey from my home purchase 3 years ago. This is my property." He pulled out his phone and made a call, speaking in low tones I could not quite make out over the construction noise. After a few minutes, he hung up and turned back to me. "My supervisor says to keep working. The HOA assured us everything is properly permitted and legal. If you have a dispute, you need to take it up with them." "You are building on my land," I said, my voice rising despite my best efforts to stay calm. "I am telling you right now as the property owner that you do not have permission to be here." "Sir, I understand you are upset, but I have a contract and a construction timeline. Unless you have some kind of court order, I cannot just stop a project this size. Talk to the HOA." I grabbed my coffee and headed back to my house, my mind racing. The HOA office was located in the community center about half a mile away. I drove over immediately, still in my weekend clothes and probably looking as agitated as I felt. The community center was a single-story stucco building painted in the same beige tones as every other structure in Meadowbrook Heights. Inside, the air conditioning was cranked high enough to make me shiver after coming in from the heat. The receptionist, a young woman named Emily who I had spoken with a few times about pool passes, greeted me with her usual cheerful smile. "Hi, Quentin. What brings you in today?" "I need to speak with whoever is in charge of the new parking structure project. Immediately." Her smile faltered at my tone. "That would be Brenda Morrison. She is the HOA president. Let me see if she is available." She picked up her phone and had a brief conversation before nodding toward the hallway. "Second door on the left. She can give you a few minutes." Brenda Morrison was exactly what central casting would send if you ordered a middle-aged HOA president. She appeared to be in her mid-50s, with carefully highlighted blonde hair cut in a severe bob, wearing a crisp white blouse and navy blazer despite the fact that it was a Saturday morning. Her office was decorated with various certificates and photos of her at community events, always positioned front and center. "Mr. Jacobson," she said without getting up from her desk. "Emily said you had concerns about the parking structure." "I can assure you, Everything has been properly approved through the county, and you are building it on my property," I interrupted. "The construction is taking place at least 15 feet over my property line." Brenda's expression did not change. She reached into a desk drawer and pulled out a folder, flipping through it before turning it around to show me. According to the community plat map filed with the county, that lot is designated as common area. It has been since the subdivision was developed 8 years ago. I leaned forward to look at the map she was showing me. It did indeed show the lot marked as common area. "That map is wrong. I have a survey from my purchase 3 years ago that clearly shows that land as part of my property. My deed includes it. Property lines are established by the original plat. Your survey must have been in error. My survey was done by a licensed professional before my purchase. My title insurance company reviewed it. This is my land, and you need to stop construction immediately." Brenda closed the folder and folded her hands on top of it. "Mr. Jacobson, I understand that you might be confused about property boundaries. Many homeowners are not familiar with how these things work. But I assure you, the HOA has done its due diligence. We have been planning this parking structure for 2 years. We have county permits. We have architectural approval. We have everything we need." The condescension in her voice made my jaw clench. "I am not confused. I know exactly where my property lines are. If you do not stop construction, I will have to take legal action." "That is certainly your right," she said coolly. "But I should warn you that fighting the HOA on something like this will be expensive and time-consuming. The HOA has significant legal resources. You might want to reconsider before going down that path." I stood up, my chair scraping against the tile floor. "Stop building on my land. Have a nice day, Mr. Jacobson." I left the community center furious and immediately started making phone calls. The first was to a property attorney named Richard Chen, whose name I found through a quick internet search and positive reviews. His receptionist said he could see me Monday afternoon. The second call was to my title insurance company. After being transferred 3 times, I finally reached someone who could pull up my file. She confirmed that yes, my policy covered the full extent of the property as shown in the survey, including the disputed land. She said I should file a claim and they would investigate. By Monday morning, the construction crew had dug deeper foundations and was setting up forms for more concrete work. I took dozens of photos and videos from every angle, making sure to capture the construction equipment clearly on what I knew was my land. Richard Chen's office was in a modern glass building in downtown Chandler. He was a slim man in his 40s with wire-rimmed glasses and an air of calm competence that I found immediately reassuring. "Tell me everything," he said after we shook hands and sat down in his office. I walked him through the entire situation, showing him photos on my phone, the survey from my home purchase, and the plat map Brenda had shown me. He listened without interrupting, occasionally making notes on a legal pad. When I finished, he leaned back in his chair. "Okay. First thing we need to do is get a new survey done immediately by a different company than the one you used before. We want to eliminate any question about accuracy. Second, I am going to draft a cease and desist letter to the HOA and the construction company. Third, we are going to pull every document related to this property from the county records and your title company. Fourth, we will file for a temporary restraining order to stop construction until this gets sorted out. How long will all that take? The survey can probably be done within a few days if we mark it urgent. The cease and desist goes out today. The TRO hearing will probably be within 2 weeks, depending on the court schedule. This is going to move fast once we get started, but these things are never as fast as we would like. And you think I have a case? Richard took off his glasses and cleaned them with a cloth from his desk. Based on what you have shown me, yes. Your survey is from a reputable company. Your title insurance accepted it. Your deed description will be key if it includes metes and bounds that encompass this land. Then you own it, regardless of what some outdated plat map shows. Plat maps can be wrong. They get amended. But deeds are deeds. The HOA president basically threatened me, said they have extensive legal resources and I would be wasting my time and money. Richard smiled slightly. HOAs love to throw their weight around, and yes, they do often have legal funds, but that does not mean they are right. Let me look into this and we will proceed from there. My retainer is $5,000 to start. Are you comfortable with that? I nodded. It was a lot of money, but what choice did I have? I wrote the check. Over the next 3 days, things moved quickly. A new surveying company came out and spent half a day measuring and marking boundaries. Their results matched my original survey. Almost exactly the land where construction was happening was mine, by about 18 feet at the deepest point of encroachment. Richard filed the cease and desist letters. The construction company responded through their lawyer that they were working under contract with the HOA and would continue unless ordered to stop by a court. The HOA's response was even more aggressive, with their attorney claiming I was interfering with legitimate community improvement and threatening to fine me for harassment of contractors. The temporary restraining order hearing was scheduled for a Thursday morning, 10 days after I first discovered the construction. By then, the parking structure's foundation was nearly complete. Every day I watched more of my property get covered in concrete and rebar. Judge Michael Patterson presided over the hearing in Maricopa County Superior Court. He was an older man with gray hair and a no-nonsense demeanor. Richard presented our case first, showing the surveys, my deed, and photos of the construction clearly on my property. The HOA's attorney was a woman named Sandra Whitmore, who wore an expensive suit and spoke with the kind of confidence that comes from winning a lot of cases. She argued that the community plat was the controlling document, that the parking structure had been properly planned and permitted, and that stopping construction at this point would cost the HOA hundreds of thousands of dollars and deprive homeowners of needed parking. Your Honor, Richard countered, the cost of the HOA's mistake is not my client's responsibility. They built on land they do not own without permission, despite being directly told by Mr. Jacobson that the land was his. This is not a good faith boundary dispute. This is trespassing and property damage on a massive scale. Judge Patterson reviewed the documents for what felt like an eternity. Finally, he looked up. I am going to grant the temporary restraining order. Construction must stop immediately until this matter can be properly adjudicated. The surveys presented by the plaintiff appear credible and directly contradict the plat map being relied upon by the defendant. This requires a full hearing to resolve. Sandra Whitmore stood up quickly. Your Honor, the HOA requests an expedited hearing schedule. Every day of delay costs significant money. Perhaps you should have verified property ownership before breaking ground, Judge Patterson said dryly. But yes, I will expedite this. Full hearing in 30 days. In the meantime, all construction stops. I wanted to cheer, but managed to keep my composure as we left the courtroom. Richard shook my hand in the hallway. That went as well as we could have hoped. Now we prepare for the main event. The next 30 days were a whirlwind of document review, depositions, and increasingly hostile encounters with HOA board members. Brenda Morrison began showing up at my house to inspect various aspects of my property, claiming she was checking for violations. She cited me for my trash cans being visible from the street 15 minutes before pickup, for a tiny patch of weeds in my rock landscaping, and for having a garden hose that was not beige approved. I documented everything and forwarded it all to Richard, who added harassment to our claims. The title insurance investigation came back definitively in my favor. Their examiner found that the original plat map had been amended twice since the subdivision was developed, and the second amendment specifically carved out my lot to include the disputed land. The county had the amendment on file, but somehow it had never been updated in the HOA's records. Either they had been working from an outdated map, or they had simply ignored the amendment. When Richard discovered this, he called me immediately. "Quentin, this is even better than I thought." The HOA did not just make an honest mistake, they had access to the correct information and either ignored it or never bothered to check. This moves from simple trespass into willful disregard of property rights. What does that mean practically? It means we can ask for more than just stopping construction. We can seek damages for the loss of use of your property, we can seek attorney's fees, and we can make them an offer they would be foolish to refuse. What kind of offer? They want this parking structure. They have already spent, according to the construction contracts I have seen in Discovery, about $400,000 on this project. If they stop now, they lose all of that and still have no parking structure. So we offer to sell them the land at full market rate, of course. I had not considered that option. How much would that be? I have a commercial appraiser coming out next week, but based on comparable land sales in the area, I would estimate somewhere between $200,000 and $300,000. For the HOA, that is cheaper than abandoning the project and starting over somewhere else. For you, it is a significant windfall for land you were not using anyway. And if they refuse, then we go to trial, we win, and they have to tear it all down and restore your property at their expense, which will cost them even more. The appraisal came in at $275,000. Richard sent a formal offer to the HOA. They could purchase the land for that amount, plus $100,000 in damages for trespass and loss of use, plus my attorney's fees, which were already approaching $30,000. Total package, just over $400,000. The HOA board held an emergency meeting. I was not invited, but I heard about it from neighbors who attended. Apparently, Brenda Morrison insisted they should fight it, claiming that giving in would set a bad precedent. But other board members, particularly the treasurer, pointed out that fighting and losing would cost even more, and their insurance might not cover it since they had arguably been negligent in checking property boundaries. The meeting reportedly got heated, with homeowners angry that the HOA had created this mess in the first place, and was now talking about spending hundreds of thousands of dollars to resolve it. A week before the scheduled trial, Sandra Whitmore called Richard with a counteroffer. $275,000 for the land, $50,000 in damages, and each side pays their own attorney's fees. Richard called me to discuss it. It is not everything we asked for, but it is substantial. Your net after my fees would be around $270,000, and it is certain versus going to trial where anything can happen. What do you think we would get at trial? Honestly, probably close to what we are asking for. The facts are strongly in our favor. But there is always risk, and trials are expensive. If you want my recommendation, I would counter at $275,000 for the land, $75,000 in damages, and they pay your attorney's fees. That splits the difference and gets you to a clean number. Do it. The negotiations went back and forth for another few days before settling at $275,000 for the land, $65,000 in damages, and they would pay $35,000 of my attorney's fees. Total to me, $305,000 after accounting for Richard's remaining fees. The settlement was contingent on court approval and proper documentation of the land transfer. We went before Judge Patterson again for the final hearing. Brenda Morrison attended this time, sitting in the front row behind Sandra Whitmore, her expression rigid with barely contained anger. She stared at me throughout the proceedings like she was trying to set me on fire with her mind. Judge Patterson reviewed the settlement terms carefully. Let me make sure I understand this correctly. The HOA built a parking structure on land they did not own, despite being informed by the owner that it was his property. They continued construction even after being told to stop. And now they are purchasing that land for market value and paying damages. Is that correct? Yes, Your Honor, Sandra Whitmore said quietly. Mr. Jacobson, are you satisfied with these terms? I am, Your Honor. Very well. The settlement is approved. I want to add for the record that this is an expensive lesson for the HOA about the importance of proper due diligence before undertaking major construction projects. Mr. Jacobson could have insisted on demolition and full restoration, which would have cost significantly more. I suggest the HOA consider themselves fortunate. We signed all the paperwork that afternoon. The land would officially transfer to the HOA within 30 days, once the funds cleared and the deed was recorded. In the meantime, construction could resume. I thought that would be the end of it, but I underestimated Brenda Morrison's capacity for vindictiveness. 2 days after the settlement was finalized, I received a notice that I was being fined $5,000 for unauthorized modification of common area landscaping. The notice claimed that 3 years ago, when I moved in, I had removed several shrubs that were technically on common area land adjacent to my property. I called Richard immediately. Can they do this? He sighed. Let me see the notice. Forward it to me. An hour later, he called back. This is garbage. First, the statute of limitations for that kind of violation would have passed. Second, the plants they are claiming you removed are not shown in any photos from before you moved in, so they probably never existed. Third, this is obvious retaliation. Forward me any other communications you get from the HOA. Over the next 2 weeks, I received 8 more violation notices. My house was supposedly the wrong shade of tan. My mailbox was 2 inches too tall. My doormat was not an approved style. My garage door was open for longer than the 30-minute maximum during the middle of the day. On and on. Every single one was either completely fabricated or an absurdly technical reading of HOA rules that no one actually followed. I watched as my neighbors left their garage doors open for hours with no complaints. I compared my mailbox to a dozen others on my street, all exactly the same height. Richard drafted a strongly worded letter accusing the HOA of harassment and retaliation, threatening to file a separate lawsuit if it continued. He sent copies to every member of the HOA board, not just Brenda. That seemed to slow things down, but it did not stop. Brenda took to driving past my house multiple times per day, sometimes stopping to take photos. Once, I caught her walking around my backyard without permission. I called the police to report trespassing. The officer who responded was a young guy named Martinez who seemed genuinely confused by the whole situation. So she is the president of your HOA? Yes, but that does not give her the right to come into my backyard without permission. He nodded slowly. I will talk to her. But honestly, sir, unless you want to press charges, there is not much I can do. And if you press charges, it will probably make things worse with your HOA. Things are already pretty bad. Officer Martinez went next door to where Brenda had retreated when she saw me calling the police. I watched from my window as they spoke on the sidewalk. She was animated, gesturing frequently. He mostly just nodded. After about 10 minutes, he came back to my door. She says she was inspecting the property boundary to ensure the new survey markers were properly placed. She says as HOA president, she has a right to verify property lines. The property line is not in my backyard. And no, she does not have the right to enter my property without permission, regardless of what position she holds. Like I said, you can press charges for trespassing if you want. Otherwise, I have given her a warning to stay off your property. I decided not to press charges, mainly because Richard advised against escalating things further while we were waiting for the final land transfer to close. Once this is done and the money is in your account, you can decide if you want to pursue the harassment angle. But for now, let's not give them any excuse to back out of the settlement. The 30 days passed slowly. Brenda continued her drive-bys, though she did not enter my property again. I received 3 more bogus violation notices, which Richard added to his growing file of harassment documentation. Finally, the closing day arrived. We met at a title company office in downtown Chandler. The HOA was represented by Sandra Whitmore and 2 board members, but notably, not Brenda Morrison. I found out later that the other board members had insisted she not attend because they were worried about what she might say or do. The closing itself was anticlimactic. We signed a stack of documents. The title company verified the wire transfer of funds, and it was done. I walked out $305,000 richer, minus the taxes I would owe on what was essentially a forced sale of property. Richard shook my hand in the parking lot. Congratulations. This was a good outcome for a bad situation. Thanks for everything. I mean that. I could not have done this without you. You are welcome. And Quentin, I would seriously consider moving, not because you did anything wrong, but because that HOA president has it out for you. Life is too short to deal with that kind of harassment. I had been thinking the same thing. The house was nice, but it was not worth the constant stress of dealing with Brenda and her petty tyranny. Within a week, I had listed the property for sale. The parking structure was completed about 3 months later. It was actually a nice-looking building, with desert landscaping and shade structures that fit the neighborhood aesthetic. I could admit that the community needed the parking. The problem was never the structure itself. It was the HOA's complete disregard for property rights and basic due diligence. My house sold quickly. The real estate market in Chandler was hot, and my corner lot was desirable. I made a decent profit on top of the settlement money. The new owners were a young couple with a baby, and they seemed blissfully unaware of the drama that had unfolded. I did not tell them, though part of me felt guilty about that. But legally, the property issues had been resolved, and I had no obligation to disclose HOA disputes. I moved to a neighborhood in Gilbert, about 15 minutes away, that had no HOA at all. Just a regular subdivision with normal city regulations. The difference was immediately noticeable. No one cared what color my doormat was or whether my trash cans were visible for an extra 5 minutes. About 6 months after I moved out of Meadowbrook Heights, I got a call from Richard Chen. I thought you might want to know there is some news about your old HOA. What happened? Brenda Morrison has been removed as president. Apparently, after your situation became widely known in the community, other homeowners started coming forward with their own harassment complaints. The board launched an investigation and found that she had been systematically targeting people she did not like with bogus violations. Several homeowners have filed lawsuits. The HOA's insurance company is not happy. Good. She deserved it. There is more. Remember all those violation notices she sent you after the settlement? I had been holding on to those in case you wanted to pursue a harassment claim. Well, another attorney contacted me. He is representing 3 other homeowners in a class action against the HOA for harassment. He wanted copies of your documentation. I got your permission in our retainer agreement to share documents related to the case, so I sent them over. Your evidence was apparently some of the most clear-cut proof of targeted harassment they had seen. What happened with that? The HOA settled. Paid out a total of about $200,000 to the homeowners involved, and Brenda Morrison was permanently banned from serving on the board or any HOA committees. They also updated their enforcement policies to require oversight before sending violation notices. I felt a sense of satisfaction at that. So she finally faced some consequences. She did. And I think your case was the catalyst for a lot of positive change in that community. Sometimes it takes someone standing up to a bully to make others realize they do not have to tolerate that behavior. After we hung up, I sat in my new backyard, which I had landscaped with native plants and a small vegetable garden, and reflected on the whole experience. The situation had been stressful and expensive, even with the settlement in my favor. But I had learned some valuable lessons. First, always verify property lines before purchasing and keep multiple copies of surveys in multiple locations. Second, HOAs can be powerful, but they are not above the law. Third, standing up for your rights matters even when it is difficult and expensive. And fourth, some battles are worth fighting on principle, even if it would be easier to walk away. The $305,000 from the settlement, combined with the profit from selling my house, gave me enough to put a substantial down payment on my new place and still have a healthy emergency fund. In a weird way, the HOA's massive screw-up had ended up benefiting me financially, even if the stress and hassle had been significant. I heard through mutual acquaintances in the area that the parking structure was well used and generally appreciated by Meadowbrook Heights residents. At least something good had come out of the whole mess. And every time I drove past the neighborhood, which I occasionally did on my way to other parts of Chandler, I glanced at that parking structure and felt a mix of emotions. Anger at how I had been treated, satisfaction that I had stood my ground, relief that it was over. About a year after everything was resolved, I was at a coffee shop in Gilbert when I ran into one of my former neighbors from Meadowbrook Heights. Her name was Patricia, and she had always been friendly, even during the height of the HOA drama. "Quentin," she said warmly. "How have you been? We miss having you in the neighborhood." "I have been good, much more relaxed without the HOA breathing down my neck," she laughed. "I bet. You probably heard that Brenda is no longer president." "I did hear that. Best thing that ever happened to our community. The new board is so much more reasonable. They actually listen to homeowners instead of just issuing fines. And that whole mess with your property was a real wake-up call. The board implemented new policies requiring third-party verification before any major construction project. They also hired a new management company because the old one was apparently just rubber stamping everything Brenda wanted. That sounds like good changes. It was. You know, a lot of people felt bad about what happened to you. Some of us tried to speak up at board meetings, but Brenda would just shut us down. After you left and the truth came out about how much harassment she had been doing, people were shocked. I am glad you stood your ground. We chatted for a few more minutes before going our separate ways, but the conversation stayed with me. It was validating to know that my fight had not been in vain, that it had actually led to meaningful improvements for other people. The legal system had worked the way it was supposed to, more or less. It had been slow and expensive, but ultimately justice had been served. The HOA had been forced to pay for their mistake and their misconduct. Property rights had been upheld, and a petty tyrant had been removed from power. I thought about all the people who might have just given in when faced with the HOA's intimidation tactics. How many homeowners had been bullied into compliance over the years because fighting back seemed too hard or too expensive? My case had shown that it was possible to win, even against an organization with significant resources and legal backing. The financial outcome had been good, but the principle mattered more. No one should be able to build on someone else's property without permission, regardless of how much power or authority they think they have. And no one should be harassed and targeted simply for standing up for their rights. In the end, I was glad I had fought. Yes, it had been stressful. Yes, it had consumed months of my life. Yes, it had cost money even with the settlement. But I had won, and more importantly, I had sent a message that homeowners do not have to accept abuse from their HOAs. My new life in Gilbert was peaceful. I got to know my neighbors, who were normal people without the strange power dynamics that seemed to infect HOA-controlled communities. My garden grew beautifully, with tomatoes and peppers and herbs that I used in my cooking. I adopted a dog, a rescue mutt named Cooper, who loved to lounge in the Arizona sun. Every so often, I would think about that moment when I first saw the construction crew on my property. The shock and anger I had felt. The disbelief that the HOA could be so careless and arrogant. If I could go back and talk to myself in that moment, I would tell him that everything was going to work out. That standing up for his rights was the correct choice. That the stress and difficulty would be temporary, but the principle would be permanent. I would also tell him to document everything, keep copies of every communication, and hire a good attorney immediately. Those practical steps had made all the difference. The parking structure still stood in Meadowbrook Heights, a testament to both the community's need for parking and the HOA's spectacular failure to do basic due diligence. But it stood on land that they had properly purchased, at a fair market rate, after being forced to acknowledge their mistake. That seemed like a fair outcome to me. As for Brenda Morrison, I never saw or heard from her again after the closing. I occasionally wondered if she had learned anything from the experience, or if she was still out there somewhere, convinced that she had been right all along. Some people are incapable of admitting fault or changing their behavior. But that was no longer my problem. I focused on my new life, my new home, and the freedom that came from not having to worry about petty HOA rules and vindictive board presidents. I could paint my front door any color I wanted. I could leave my garage open all day if I felt like it. I could plant whatever I wanted in my yard without getting approval from a committee. These were small freedoms, perhaps, but they mattered. They represented the fundamental right to control your own property and make your own choices without interference from busybody neighbors with too much time and authority. The money from the settlement was nice, but the peace of mind was better. And knowing that my case had helped other homeowners and led to positive changes in the community gave me a sense of satisfaction that money could not buy. Richard Chen and I stayed in occasional contact. He sent me a Christmas card that first year, with a note thanking me for being a good client and joking that I had given him some of the most clear-cut property law issues he had seen in years. I sent him a bottle of good scotch as a thank-you gift. He had earned every penny I paid him, and then some. The experience had taught me to be more careful about where I chose to live. When I eventually decided to upgrade from my Gilbert house, I made sure to thoroughly research any HOA or community association, looking for red flags like high turnover in board positions, lots of lawsuits, or complaints about overzealous enforcement. I also made sure to get the most comprehensive title insurance policy available and to have a detailed survey done by multiple companies. Some might call that paranoid. I called it being educated by experience. Years later, I was at a real estate conference in Phoenix. I had gotten my real estate license as a side business when the topic of HOA disputes came up during a panel discussion. One of the panelists mentioned a case from a few years back where an HOA had built a parking structure on private property and been forced to buy the land. "That was my case," I said during the Q&A session. The room got quiet, and then the panelist asked me to come up and share my story. I spent 20 minutes talking about the experience, the legal process, and the lessons I had learned. The audience was riveted. Afterward, at least a dozen people came up to share their own HOA horror stories or to ask for advice on dealing with similar situations. It struck me that my experience, as unique as it had seemed at the time, was actually part of a much broader pattern of HOA overreach and abuse. There were thousands of stories like mine across the country, though perhaps not all quite as dramatic as having a parking structure built on your land. The more I learned about the HOA industry, the more troubled I became. These organizations, which were supposed to maintain property values and provide services to homeowners, had in many cases become little fiefdoms where petty bureaucrats wielded disproportionate power over people's lives and property. The lack of oversight and accountability was disturbing. But I also met board members who genuinely cared about their communities and tried to do the right thing. The problem was not the concept of HOAs itself, but the way power could corrupt, especially when combined with vague rules and inadequate checks and balances. My story became something of a cautionary tale in real estate circles in the Phoenix area. Agents would mention it when advising clients about HOA properties. Attorneys would cite it as an example of the importance of proper due diligence. And homeowners facing their own HOA disputes would reach out to me for advice and encouragement. I always told them the same thing. Document everything, know your rights, do not be afraid to stand up for yourself, and hire a good attorney if necessary. Most disputes did not need to go to court, but having legal representation often convinced the other side to be more reasonable. The financial windfall from the settlement had long-term benefits I had not anticipated. I was able to invest a significant portion of it, which grew over the years and provided security and options I would not have otherwise had. I paid off my student loans. I helped my sister with her medical bills when she got sick. I took a trip to Europe I had always dreamed about. But more than the money, I valued the knowledge that I had stood up for what was right, that I had not been intimidated or bullied into submission, that I had fought and won against an organization that thought it could do whatever it wanted without consequences. The story had a satisfying ending, which is not always the case with legal disputes. The bad actors faced consequences. The system, while slow and imperfect, ultimately delivered justice, and I came out ahead both financially and in terms of life lessons learned. Sometimes I drove past Meadowbrook Heights just to see the parking structure. It still made me shake my head in disbelief that they had been so careless and arrogant. But it also made me smile, knowing that every car parked there was parked on land they had been forced to buy from me at market rate. The corner lot where my old house stood looked good. The new owners had updated the landscaping and added some nice touches. I hoped they were happy there and that the reformed HOA was treating them well. They had bought into a better version of the community than the one I had dealt with, thanks in part to the changes forced by my case and others like it. As the years passed, the whole experience became just one part of my life story, though an important one. It shaped how I approached problems and conflicts. It taught me the value of standing firm on matters of principle. And it gave me confidence that I could handle difficult situations and come out okay on the other side. I never regretted fighting the HOA, even during the most stressful parts of the process. It was absolutely the right decision, both morally and practically. And I never regretted moving to a non-HOA neighborhood, where I could live my life without worrying about arbitrary rules and vindictive enforcement. The parking structure stood as a monument to the importance of property rights and the rule of law. It was a reminder that even powerful organizations have to follow the rules, and that individual homeowners can successfully fight back when their rights are violated. And every time I told the story, whether at a conference or to friends over dinner, or to someone seeking advice about their own HOA dispute, I emphasized the same points. Know your rights, document everything, do not be intimidated, and get professional help when you need it. The legal system is not perfect, and justice is not always swift or cheap. But in my case, it worked. The HOA built their parking structure on my property, and the court made them buy the land at market rate, compensate me for damages, and pay my legal fees. It was exactly the outcome I deserved, and I was grateful for every person who helped make it happen. Looking back on the whole saga, from that first morning when I saw construction equipment on my property to the final closing and beyond, I realized that the experience had changed me in fundamental ways. I was more confident, more knowledgeable about my rights, and more willing to stand up to authority when it overstepped its bounds. The $305,000 settlement was nice, but the real value was in the lessons learned and the principle established. No one could ever again say that HOAs can do whatever they want without consequences. At least in my case, they had learned the hard way that property rights matter and that homeowners are not powerless. And that, more than anything else, made the whole difficult experience worthwhile.